So welcome to the Solid Speaker Series. We're very privileged to have very distinguished folks to discuss law of the sea tonight. But before we do that, so today we're very privileged and I'm very excited to welcome probably the leading person on law of the sea issues. He was present at the creation of UNCLOS. That's Ambassador Tommy Koh, Ambassador at Large at the Singapore Ministry of Foreign Affairs, Chairman of the Center for International Law, Rector of Tembusi College at National University of Singapore, and Special Advisor at the Institute of Policy Studies. Ambassador Koh was the president of the third UN Conference on the Law of the Sea. He chaired the PrepCom and the main committee at the Earth Summit. He was Singapore's permanent representative to the United Nations for 13 years, ambassador to the United States for 6 years, and the UN Secretary General's special envoy to Russia, Estonia, Latvia, and Lithuania. He was Singapore's chief negotiator in negotiating the US-Singapore Free Trade Agreement. He chaired the high-level task force, which drafted the ASEAN Charter. He acted as Singapore's agent in the case concerning Piedra Branca before the ICJ and in the land reclamation case before it lost. His many publications include the one that will be featured tonight. It's right here, Building a New Legal Order for the Oceans. His other work on law of the sea issues is also right there, the South Sea China arbitration, co-authored by his fellow panelists tonight. And he's authored so many other books that I can't mention, but I have to add a few more things. That's the official bio. But basically, his current goal right now is to publish 3 books a year. He's often running into doing that right now. Among the books he promises, anxious to have a session on that, is a book on explaining America, hopefully to a foreign audience, although some of us in the US could benefit from that as well as a book on the contributions of small countries, and which is also sounds fascinating. If you happen during this session to look up his Wikipedia page, you will discover 31 honors. And these are not small honors. We're talking about the Wolfgang Friedman Award at my old school, Columbia University, the Jackson Rolston Prize at Stanford, the Commander Order of the Golden Ark from the Netherlands, and the Encomienda of Isabel la Católica from His Majesty King Juan Carlos of Spain, Champions of the Earth Award from the UN Environmental Program, the Order of Vilma Ultima, doesn't indicate the country for that one. The Order of the Rising Sun, that one I can recognize from Japan, and the Great Negotiator Award from the Harvard Law School just in 2014. If you are still curious, and you should be, you should pick up this book, which tells you that other than being a great negotiator, he is a great establisher of institutions, including the Center on International Law at the University of Singapore, which he had a role in establishing, along, of course, with its first director, Robert Beckman, who's about to join us as well. And he is also responsible for a cultivator of the arts. So if anyone goes to Singapore, has to go to the Asian Civilizations Museum, and that's his baby as well. So I'm extremely honored to have you, Ambassador Koh, and I'm also very privileged and honored to have you engage in conversation with another total expert on law of the sea, Robert Beckman, who's Professor Emeritus at the National University of Singapore, where he heads the Center for International Law's Ocean Law and Policy Program. He founded the Center of International Law, a university-wide research institute closely affiliated to the Faculty of Law there. He led it from 2009 until 2016. And for many years, he taught public international law, international legal process, introduction to the legal method. But perhaps he's most famous for bringing Singapore to various wins, perhaps more wins than any single person on earth, in the Jessup Moot Court competition that now bears his name in Singapore because of his, and he refuses to tell us the secret sauce for this. So at some point we will extract a truth serum to make sure he spreads that knowledge beyond that. He has a global reputation as a scholar of ocean law and is one of the world's experts on the South China Sea. The way this will go is they will engage in conversation for some 45 minutes or so, leaving plenty of time to engage in conversations with all of you. Hopefully, you will put your questions at any moment in that you have the question written out, write it out in the Q&A function, and then I will turn to it in the second half of the program where they can engage in those questions. Well, I turn it over to both of you. Whoever wants to go first, perhaps Professor Beckman, you want to pose the first question, and I'll just disappear.
Thank you. I guess I can pose a question to Tommy in terms of a large part of his book. He talks about what I call the grand bargain on passage rights especially for militaries, and resolving some of the problems that were left over and they couldn't reach agreement on in the 58 conventions, but especially the breadth of the territorial sea. So it might be good if Tommy would explain those issues, because the central to the discussion on that was Southeast Asia, because Indonesia sits on the choke point between, or the fulcrum between the Indian Ocean and the Pacific Ocean, and it was these particular issues and their claim for archipelagic states that posed one of the most difficult problems facing the negotiations when they began in 1973. But I think rather than me try to explain it, I think Tommy, as an insider, would perhaps add more insights. So Tommy, can you take off on that one?
Sure. Now, Bob, I hope you don't mind if I backtrack a little bit.
Sure.
And explain why the conference was convened, the relevance of the agenda to Southeast Asia. As you know, after the war, especially in the 50s and 60s, there was a multiplicity of claims to maritime zones, territorial sea, fishing zone, and so on. And countries even went to war over fish. You may remember that Iceland and United Kingdom engaged in a short war over cod. Things were that bad, So there was a state of legal chaos in the world. There was no agreement on the maximum breadth of the territorial sea, no agreement on fishing rights, no agreement on the continental shelf limit, no agreement on the claims by country like Indonesia to special status as an archipelagic state. So these were the reasons that led the UN to convene the conference. There were two issues very important to Southeast Asia. If we expand the territorial sea from 3 miles to 12 miles, then there are 116 straits in the world, which are often used for international navigation, which are narrower than 24 miles. If you extend the territorial sea to 12 miles, it means that the international waters on these straits would have disappeared. And the great maritime powers made it clear that they will not accept the extension of the territorial sea from 3 to 12 months unless there's a special regime of passage for ships and aircraft and submarines through and over these international straits. This is an issue very important to Malaysia, Indonesia, and Singapore. There's another issue very, very important to my neighbors, especially Indonesia. Indonesia was one of the many countries, including Fiji, Mauritius, and a few others, whose national territory consists of a group of islands which are in close proximity. And these countries want the international community to recognize their special legal status as an archipelagic state. Well, if we recognize such a thing and we allow them to draw straight lines linking the outer island, then what happened to the status of the waters enclosed? If they become archipelagic waters, then what happened to passage right? So this is an issue very much like international strait. the great maritime power said, we will not recognize the so-called archipelagic states unless there's a special regime of passage called archipelagic sea lane passage through archipelagic waters. So these are some of the issues which are of great importance to countries in this region.
Okay, thanks, Tommy. I'm wondering whether you could say a bit on how that agreement was reached in terms of the recognition of a 12-mile territorial sea with transit passage. And as you said, was critically important to the naval powers because the transit passage rules and archipelagic sea lanes passage allow ships to pass in their normal mode. The normal mode, of course, was code language for submarines being able to go submerged. That is also, if you're going to move your aircraft carrier from the Indian Ocean to the Pacific Ocean, you want other ships in formation to be able to provide cover for it, and you want air cover above. So this was critically important. But how did it actually, was it a small negotiating group? This clearly wasn't negotiated on the floor of the conference.
Okay, very good question. By the time the conference convened, the 3-mile limit for territorial sea was no longer viable because a majority of the member states of the UN had unilaterally extended the territorial sea to 12 miles. So it was inevitable that the conference would recognize a new limit for the territorial sea of 12 miles. But the problem is we cannot get the concurrence of the great maritime powers unless we work out a special regime of passage in the international straits or straits used for international navigation. In the plenary of the conference, we were completely stuck. There was just impasse. So 2 leading delegations at the conference, Fiji and the United Kingdom, took it upon themselves to convene a private group on straits. I want to say that such an initiative would not be countenance today. Many of the things we did in the UN Conference on the Law of the Sea cannot be replicated today because everyone wants to participate. Nobody is willing to allow some conference leader to convene a private negotiating group to try to solve some of these very difficult issues. But during the UN Conference on the Law of the Sea, partly out of desperation and partly because we were stuck on these difficult issues, so we allow Fiji and the United Kingdom to convene a small private negotiating group on straits, consisting both of strait state, moderate strait state, and maritime state, excluding the 2 superpowers. Indonesia and Malaysia were extremely angry that they were excluded from the group. And the 2 co-chairmen, Fiji and the United Kingdom, had to explain that their views were too extreme and would not lead to a consensus. In the same way, they excluded the United States and the Soviet Union. Anyway, after a lot of hard work, we succeeded in adopting a set of draft treaty articles which were submitted to the conference and found their way into the single negotiating text. And although in the plenary, several delegations attacked those, but they attracted consensus, because it reflected the only viable compromise and was supported by a majority of the delegations at the conference. The same thing happened when Jens Evensen, the leader of the Norwegian delegation, convened a private group to work out the draft treaty articles on this new concept called exclusive economic zone. And yet another conference leader, the leader of the Mexican delegation, Jorge Castaneda, convened a private negotiating group to solve one of the most difficult issues at the conference, which was, what was the legal status of the exclusive economic zone? Is it part of the high sea, part of the territorial sea, sui generis? What are the rights of the coastal state and rights of the international community. So there were many of these private initiatives taken during the conference, which led to solutions. If not for them, we would not have cracked some of the very difficult issues. But I think in the contemporary world, they probably would not be accepted.
Okay, Tommy, let me just add a little bit and then ask you to comment further, because again, the impetus for the convention in many ways was Arvid Pardo's speech calling for the deep seabed resources to be the common heritage of mankind. So there is what I call the grand bargain on resources, which was reached in the convention. The economic zone was critical to it, but is also linked to a 12-mile territorial sea, sovereignty over archipelagic waters, a 200-mile economic zone, but then they had to come up with a new definition of continental shelf unless they stopped continental shelf rights at 200 nautical miles. Because the old definition in the 58 convention was very weak because it allowed for creeping jurisdiction. It said you can claim a shelf out in so far as technology allows you to drill, right? But then, so that you had a third world countries pushing for common heritage principle, you had the coastal states pushing for economic zone, and then you had the archipelagic states wanting complete sovereignty over all the resources within their archipelagic waters. You said there were two groups on economic zone. I'm curious as to how did two negotiating groups deal with it, and which group dealt with the definition of continental shelf? Do you recall?
There was a formal negotiating group on the continental shelf. And to some extent, the unilateral action by the United States in the form of the Truman Proclamation set the baseline, the issue before the conference, and also we have the 1958 convention. The tricky issue for the conference to deal with was, should we stop the line at 200 miles, or should we allow coastal states to claim that we must allow the continental shelf limit to extend to the base of the continental margin, which may be beyond 200 miles. The compromise was that it could be extended to the base of the continental margin, but there must be profit sharing of revenue derived from the exploitation of the continental shelf beyond 200 miles. So this is the compromise arrived at.
Yeah, that's Article 82, and that's to be administered by the Seabed Authority. And I think they're still negotiating how that is going to be paid and how it's going to be administered. Yeah. But there's one other issue on the economic zone that it is a sensitive issue in Southeast Asia, and that's the jurisdiction of the coastal state versus high seas rules of jurisdiction, because both apply at the same time. The jurisdiction, coastal state has jurisdiction over economic activities. Other activities are governed by the high seas rules on jurisdiction, which is primarily exclusive jurisdiction of the flag state. But a very sensitive issue, I understand, was what about military activities in the economic zone?
Yes.
15 or 20 miles off the coast. Many coastal states feel threatened by that. The military is out doing reconnaissance just off their territorial sea. How is that resolved?
This is one of those really difficult issues. And the two superpowers, the United States and the Soviet Union, again told us, if we don't get concession from the developing countries, there would be no convention. So it was very difficult. Those of us who wanted a convention and the coastal states who wanted an economic zone had to accommodate this demand by the two superpowers. The question, how do you do it? So Ambassador Castaneda of Mexico took it upon himself to convene a private negotiating group, which work mostly after dinner at night. And after many nights of hard work, we agreed upon a set of articles which are deliberately ambiguous. Many developing countries say they cannot accept a specific mention that military activity would be permitted in their exclusive economic zone. And so Castaneda and company managed to draft a set of articles which imply that it's permissible. So the balance is this. In the exclusive economic zone, coastal states have sovereign right to the resources, but they don't have sovereign right to the water column. Unfortunately, post-convention, many coastal states are trying to do the opposite. They're trying to claim that they have sovereign right, not just to the resources, but also to the water column. This is not correct. This is not what the convention say. This is not the intention of the drafters of the convention. But the drafter of the convention basically is saying through these ambiguous articles in the convention that on passage rights, on other rights, the law applicable to the water column in the exclusive economic zone are those of the high seas. And of course, on the high seas, military activities are permissible. So by logic, the conclusion is the better conclusion. I mean, this is disputable. In my view, the better conclusion is that military activity are permitted by the convention in the exclusive economic zone.
Yeah, I travel the region a bit, and I'm constantly questions are always raised on this issue. For those law of the sea people, you look at Article 58.1 of the convention, which talks about the freedoms of navigation and overflight and laying of submarine cables and the key language here, which is what the militaries rely on, and other internationally lawful uses of the sea related to those freedoms. That is the code language which says lawful use of the sea relating to freedoms of navigation and overflight is the historic naval activities, including naval reconnaissance. And that's the understanding, I think, which most states now have of the convention.
Yeah.
The other one, if you look at Article 56, it only gives the coastal state jurisdiction over activities as provided in this convention. So I tell governments when I meet them, if you can't find jurisdiction for you in the convention, you don't have it, because you only have jurisdiction over resource activities, economic activities like wind farms, offshore installations, whatever.
Yeah.
And then Article 2, paragraph 2 of Article 58, in effect says that high seas rules on jurisdiction apply in the economic zone so long as they're not incompatible with the economic zone provision. So again, for some, it's the most difficult zone to understand because in part it's like high seas, but in another part it is like the jurisdiction, especially over fisheries and offshore hydrocarbons or mineral exploitation. The coastal state has jurisdiction. That's the most difficult concept I know for students and government officials to understand. But it's a brilliant compromise. It means everything and relating to economic activity the coastal state can exploit. Little bit of a problem on marine scientific research. Not sure you were involved in the difficulties there.
I wasn't.
Because the convention says the coastal state's consent is required for marine scientific research. Problem is there's no definition could be reached at the conference on what marine scientific research is. So the argument is that if a state applies for permission to do marine scientific research, it's a matter, of course, the coastal state should consent it. Coastal state could participate if they like or reach the results. The difficulty is military reconnaissance in many countries, in the superpowers' views, is not marine scientific research. Marine scientific research that requires consent is research that could prejudice the economic interests of the coastal state.
Yeah.
Research about their fisheries, could be utilized for minerals, whatever.
Yeah,
that was a compromise, but there's still a lot of confusion on those issues.
Yeah, I agree.
Sometimes states, there really isn't confusion, but they want to pretend there's confusion because they don't like the compromise that was reached.
Well, I look forward to the day when some of these difficult issues are adjudicated, either by a court or tribunal, so that we have more clarity,
Okay, then let me lead you to one more point I can, and that's the articles in the convention which were left intentionally ambiguous. And one of those would be Article 121 on rocks and islands.
Okay.
And I'm wondering whether you wanted to comment on that, because it's critical that if you are the sovereignty over an offshore island that is very tiny, and you claim an economic zone from that, well, then you could seriously impair or cut into the economic zone of the land of the major continental territory that is. So that was a difficult issue. I don't sense that there was that much debate on it, but it was sort of left vague. I would argue 121.3 is difficult.
Yes. Well, islands versus rocks was one of the most difficult issues in the conference. You look at the relationship between Turkey and Greece, from the point of the Turks, all these little islands shouldn't have the same maritime entitlement as the mainland. But island countries hold very strongly to the opposite view, that why shouldn't they be allowed to have the same maritime zones as continental countries? So this was one of those almost impossible dichotomies to overcome. So the final compromise, not very satisfactory, is to say, if a feature is a rock, it is not entitled to a continental shelf or economic zone. But if the rock is capable of sustaining human habitation or economic life of their own, then they are so entitled. So this was the distinction in para 3 and 121. Deliberately ambiguous, because a clearer distinction between the two would not be acceptable. And there was no clarity until the South China Sea Arbitral Tribunal, which interpreted these provisions, but the tribunal held a very high bar. So their view is that none of the features in the Spratly Island qualify to be an island. Not even the biggest feature, Itu Abang, or what the Taiwanese call Taiping, qualifies. This is very controversial. A lot of people do not agree with the arbitral tribunal. They think Itu Abang or Taiping should have been recognized as an island. But this is the view of a very learned panel of 5 judges, and I think it carries weight. So if you think this view is correct, what it means is that claimants of these features in the South China Sea cannot claim an exclusive economic zone for these features. Only a small territorial sea around these rocks. And this, the geopolitical consequence of this is quite significant to the claimant countries.
Okay, Tommy, let me point out, however, that the Southeast Asian claimants surrounding the South China Sea never claimed an economic zone from the Spratly Islands. When they first made their economic zone 200-mile limit clear, it was in conjunction with making an extended continental shelf claims, a joint submission of Vietnam and Malaysia, and separate submission. Philippines didn't make it, but they made it known where their economic zone 200 limit would be. So the Southeast Asian countries claimed an economic zone only from their mainland territory or from their archipelagic baselines in the case of Philippines.
I was referring to
the arbitral tribunal in effect reinforced the practice of the Southeast Asian countries surrounding the South China Sea. But that's what put China in a big dilemma, because then even the larger islands that it claimed, it would be entitled to only a 12-mile territorial sea.
Which the Chinese have not accepted, and the Chinese continue to insist that all these features qualify as islands and are entitled to the full rights of territorial sea, economic zone, continental shelf.
Right. But the difficulty that I see sometimes is that we have now an authoritative interpretation of 121.3 for the first time. And there are states that vehemently criticize China for not complying with the decision. But at the same time, they themselves claim a 200-mile economic zone and sometimes even an extended continental shelf from features that are no larger than the features in the south than the Spratly Islands. So you're saying, well, this is good for China because it's by the legal decision it's binding, but we're not going to think about reevaluating our own position.
I agree.
Which makes it more sort of difficult for them to legitimately criticize China, because if there's an authoritative interpretation, one could argue state should reevaluate its own position on that issue. Could I ask you one more question, Tommy? And that's another intentionally vague provision. I believe it was one of the last provisions to be agreed on. Is how do you delimit the economic zone and continental shelf? There was a big debate about so-called equidistance principle as opposed to equity. Equitable principles. And there were two camps, as I understand it.
This was indeed the last issue to be resolved at the conference. And I invited my good friend from Fiji, Satyanandan, to help me. You're right. There were two competing groups of delegation, one saying equidistant, and the other saying no, equity. And they wouldn't compromise. These two groups would not compromise. So what Satyanandan and I basically did in drafting these two paragraphs is to basically say, let the court decide, as long as the outcome is equitable. The outcome must be equitable, but basically let the court decide. I know it's not satisfactory, and many people have criticized Satyanandan and me for having authored such an ambiguous text. But any other text was not acceptable to the two groups. So and I remind all those listening in that negotiation is the art of the possible, and this is the best that could be achieved.
But in fairness, Tommy, I think there's been so many cases now by the ICJ, by ITLOS, by arbitral tribunals, that there's a considerable amount of certainty now as to what rules a court or tribunal will apply in the maritime boundary delimitation. So in that sense, the vague solution that you put forward in order to reach an agreement has been a success, where there's only been one case. The ICJ has dodged the Rock Island cases in several delimitation cases it had. And it was only the South China Sea Arbitral Tribunal that could not resolve the issues unless it addressed that particular question. See, I'm trying to think if there's anything else that you'd like to raise in terms of to what extent can the procedures which were used for the 82 convention and the negotiations, to what extent can they still be followed for the current BBNJ negotiations? What are the major lessons learned? Your president of the current BB&J negotiations is a fellow Singaporean, my former student. What advice would you give Rena on this if she hasn't already asked?
I think Rena is better informed about this than I am, so I hesitate to give Rena advice. Can I just make two concluding points, Bob? I want to say that there are two arguments being made by the law of the sea community that I want to address. There's an argument made by some countries that UNCLOS is the product of the West. So we in the East, we don't have to really follow it. It's not our product. This is not true. UNCLOS was negotiated by over 150 countries, the majority of which are developing countries. And all the countries in Asia participated in negotiating UNCLOS. So it's not true that UNCLOS is a product of the West. In fact, UNCLOS is a revolutionary treaty, primarily driven by the aspirations of the developing country. And it adopted new concepts of international law, economic zone, archipelagic states, common heritage of mankind, and so on. The second point I want to make is that there is a campaign by a small group of countries to reduce the legal status of UNCLOS. And I say this is wrong. At the concluding meeting of the conference, I described UNCLOS as the constitution of the oceans. By that, I mean it is the primary law. It is not co-equal with other law. This is a primary law. This convention contains a statement of the modern law of the sea. So I just want to say that we mustn't allow this campaign to undermine UNCLOS, to reduce its status, to succeed, because it's not in our interest. So I just want to make those two concluding remarks. Thank you, Bob.
Jose, can I have permission to make two quick concluding remarks, I guess,
Sure.
before we open it for questions? I think first, something we haven't mentioned is one of the other successes of the 82 convention is it's part 12 on the marine protection and preservation of the marine environment. Recall the UN conference on the human environment was in Stockholm in 72. So when the conference began, there was already environmental consciousness, and it was the first major convention to put clear obligations on states to protect the marine environment. That is a real success, and we've built on that subsequently. The other very important point about UNCLOS is it's one of the very few conventions that every party is bound by the compulsory binding dispute settlement procedure. When you agree to go to dispute settlement with another country over provisions of the convention when you ratify accede to the convention. And if you look back at major international agreements, that's very rare to say that the dispute settlement mechanisms are compulsory. Now there's some flexibility in them, but basically you are agreeing to compulsory binding decisions by a court or tribunal, and you're accepting the jurisdiction of that tribunal when you ratify or accede to the convention. That was, and I think the rationale for that was as Tommy suggested, they knew there were vague provisions and controversial provisions. They were not naive enough to think that states wouldn't cheat and that disputes would arise. And therefore they say the convention's not going to work if everybody interprets it their own way. We need a unifying force for a common interpretation. And that again is a major achievement which the people like Tommy Ko should be credited for. I'll stop there and happy to take questions.
So there have been quite a number of questions, but let me start with Ambassador Ko. You suggested here and in other documents and other writings that it really is like the Constitution for the oceans. And of course, the oceans cover so much of the earth that it's quite a significant constitution. But I guess I want to press you when you use the term constitutions. Do you mean that to suggest that we should interpret it like we do some constitutions, and some would say we interpret the UN Charter with a much more teleological view, a principle of effectiveness, a concept of greater creativity, not just when you give provisions to the arbitrators, but because you want this to be treated a bit differently than, say, a bilateral treaty between two states for extradition. Can you say a bit more about what you mean by a constitution?
What I mean is that first, it's a comprehensive law. It aspires to govern all aspects of human activities in ocean space. And second, that it's a primary law. It is superior to other pre-existing law. And third, my aspiration when I said a constitution for the ocean was that it would be universally recognized as the modern law of the sea, you know. And I also envisage that UNCLOS will last for a very long time. So we therefore need some creativity in interpreting it in the way we interpret our domestic constitution, you know. And also that it's a living document. It can accommodate new development, whether BBNJ or something else, you know.
In fact, that is one of the questions posed, considering the latest development in technology that hasn't been addressed in UNCLOS. Do you think there should be an amendment to UNCLOS to address things like underwater unmanned vehicles?
Amending UNCLOS is politically difficult, but because of our Fijian friend Satyanandan, we've found a way of adding to the convention by way of an implementing agreement. We did that in amending Part 11, the most controversial part of the convention, in 1993. We adopted an implementing agreement of fisheries in 1994. And now if there's an agreement of BBNJ, the results of this conference will be embodied in the form of an implementing agreement, which a UN General Assembly will adopt and will be signed and ratified. You know, so we found a way of amending UNCLOS without formally amending it, which is to adopt implementing agreement.
Jose, let me comment on the underwater drones or underwater vehicles. I think that we don't need an amending agreement or anything else. I think states concerned or a court or tribunal can simply apply the principles of UNCLOS to it. There's certain principles relating to the territorial sea and passage of ships, balancing that certain things if a ship does that is deemed to be non-innocent, etc. There's freedoms of the seas begin outside the 12-mile limit. Whether the convention in effect tried to anticipate it by saying submarines and other underwater vehicles have the right of passage and must surface and fly their flag when they enter the territorial sea. Now, is an underwater vehicle or what, a drone? Is it? But I think common sense and states getting together can agree on how these provisions would be interpreted in light of the new technology. We certainly don't need another convention to deal with these issues. It's a sensitive issue now. Certain incidents have arisen in the South China Sea, but I think we can manage this issue within the convention if states complied in good faith.
So this is the U.S. Asia Institute, so I can't resist asking some U.S.-centric question. And that is, as you know, Ronald Reagan insisted on rather dramatic changes to the convention, and those were, in effect, made. And yet the U.S. remains outside of the convention. Do you think that the U.S. did not act in good faith then or even now in not being part of the convention, despite all the things that were done to satisfy that administration?
I want to answer your question indirectly. So I will say two things. First, I want to say to my American friends that UNCLOS serves your national interest. It is in the United States' interest to be a party to this convention. So many provisions in the convention have an American origin. My second point is what I say to my wife when my wife asks me, when will the United States become a party to the convention? So I tell my wife that Churchill once said, we can always depend on the United States to do the right thing after it has tried everything else. So I hope one of these days the US will ratify the convention, but it looks like you don't have the numbers in the US Senate today. You don't have 2/3 majority, so we'd have to wait longer.
Jose, can I comment?
Are you going to be less diplomatic?
Oh no, what I'm going to say is I lecture a lot to people, to government officials and all in the region, training courses we have, and invariably, every talk I've ever given or every seminar, the question is raised is, why is the United States criticizing others for not complying with the convention when it itself is not a party, not subjected itself to the dispute settlement system? And then I try to explain that all the rational groups in the United States, from the environmentalists to the oil companies to the deep sea mining to the Navy and the Coast Guard, all environmental groups, all favor ratification, but the antiquated rules of the US Senate prevented the US from getting the necessary votes to ratify it. And the US in practice actually follows the convention probably more closely than states that are not parties. Or that are parties, I mean, and it also takes it upon itself to study whether other states' actions are in compliance with it through its limits to the sea publications, et cetera. It examines everyone else's baseline claims and meritorial claims, et cetera, exercises freedom of navigation measures to challenge illegal claims, et cetera, except in one very important area. It looks at straight baseline. It never looks on rocks versus island claims. And that, some of us would say, it's because the US itself claims economic zones from very tiny features in the Pacific that, applying the criteria of the South China Sea Award, would not be entitled to an economic zone. So it's a real dilemma because it affects the US credibility in a large area, a large amount, right? In the eyes of many government officials from developing countries, they simply can't understand why the United States is not a party.
Well, I'm sure Ambassador Coe's book, Explaining America, might tell us a bit more. I can't resist noting that it took the United States 40 years to ratify the Genocide Convention.
Exactly.
So that's just a small part. Now, we have another leading expert on law of the sea, Peter Dutton, who's asked a question, and I'll just read it. One of the primary drivers of the tensions in the South China Sea that emerged after 2009 seems to have been the UNCLOS requirement for coastal states to file continental shelf claims by a date certain, which was extended to May 2009, but no further. The joint submission by Vietnam and Malaysia was taken as a direct challenge to China's claims. In retrospect, was it wise for the convention to set a specific date for coastal states to make their continental shelf claims?
I think I'll ask Bob. Bob, why don't you start?
Yeah, I can take that. In retrospect, I think they had to do something. First of all, they totally didn't anticipate how many states would be able to make extended continental shelf claims. When they drafted the provisions, they didn't understand the science, and they completely underestimated the complexity plus the number of states that coastal states that might be entitled to a claim. So eventually, remember the convention went into force in 1994. Eventually, they had to give it some kind of limit for requiring states to at least submit preliminary information. And I'm not sure of the rationale, but they chose May 2009. I think at some point they had to choose a date. Now that is linked, as Peter says, to the South China Sea claims, because what that May 2009 deadline did was it forced the states surrounding the South China Sea, the ASEAN claimants, to, for the first time, show us where your 200-mile limit is, because you can't claim an extended shelf beyond 200 unless you first show us where your 200-mile limit is. And the Malaysia-Vietnam joint claim did that. And in fact, the Philippines, if you look at the map of the Malaysia-Vietnam joint submission, they're also kind enough to show you where the 200-mile limit of the Philippines would be. And therefore, you see, you had for the first time, the significance of that was it became clear that the Southeast Asian claimants were not claiming an economic zone from any islands. They were only claiming it from their main territory. That put, of course, immediate pressure on China. And China responded the very same day or the next day. And that's when it put the infamous 9-dash line map before the international community. But I don't think it was a mistake of procedure. I think it had to be done.
Any further comment on that, Ambassador Ko?
No, I agree with Bob. Yeah.
Okay, so there are questions about bringing cases to ITLOS, and here's one of them. Singapore and Indonesia are currently having a different interpretation of UNCLOS Article 51 regarding other legitimate activities, and whether or not Singapore has traditional military exercise rights in Indonesian archipelagic waters. Do you think Indonesia and Singapore should get to ITLOS for the interpretation of Article 51? And that raises a more general question, and I would love to hear Ambassador Ko on this. How do you convince states to take a dispute like that to the court? Obviously, there are many issues now, not just this one. And we have an exercise where we're trying to explore in USALI what it takes, what convinces states to go to binding arbitration when it comes to maritime or territorial disputes, and trying to see a recipe book. So I'm curious what you have to say, not just for this, but how generally do you persuade states to send something to binding dispute settlement? What can you say that would make a difference?
I'll let Tommy handle this one.
I want to make an important point. There is culturally a fundamental difference between countries in Northeast Asia and Southeast Asia. In Southeast Asia, I think maybe we are more pragmatic, less ideological. Countries have a track record of referring their dispute to the third party. And this goes back. Cambodia and Thailand referred their dispute over a famous temple, Preah Vihear, to ICJ. Indonesia and Malaysia referred a dispute over two islands to ICJ. Malaysia and Singapore referred a dispute over an island and two other features to ICJ, and Malaysia took Singapore to arbitration and subsequently to ITLOS for provisional measures. Myanmar and Bangladesh took a dispute over the maritime limitation to ITLOS. So I want to make the point that in Southeast Asia, the countries are willing, if they can't solve that dispute by negotiation, they're willing to take it to a third party, whether it be to arbitration or to adjudication. If you look at countries in Northeast Asia, somehow, they are more advanced than we are, the older country. They have judges in these courts that we don't, and yet there's a great reluctance on their part to refer their disputes to a third party. I was once invited by the Korean Maritime Institute to be the keynote speaker at their annual conference. And they wanted me to explain to Korea, to Japan, and China the experience among the ASEAN countries and what they can learn from us. So I told Japan and China, you know, you have a dispute over Senkaku Diaoyi. I told Japan and Korea, you have a dispute over an island, Takashima, I forgot the Korean name. Why don't you guys refer this dispute to a third party, you know? And they said, no, we can't do that. That countries in possession, they say if they were to even acknowledge that there is a dispute, they will fall. The public opinion will be so hostile, you know? I say, yeah, but you should explain to your public opinion that it's better to resolve these disputes, even though you may lose, rather than have them continuing to be irritant in your bilateral relations and you know, poisoning the whole atmosphere. But China, Japan, and Korea told me at this conference that they cannot emulate the example of the ASEAN country. I was very disappointed, Jose. My wife had told me I'll be wasting my time, you know. But I say, being an idealist, I want to try to persuade China, Japan, and Korea to follow our example. But they explained to me that they can't do it.
Well, that's quite interesting, because I'm always a bit suspicious about cultural account of resistance to arbitration. But the way you put it, it suggests a sort of internal political account. That is something about the domestic legal system and the expectations of your rulers, that giving a concession may be regarded as politically disastrous. But I interrupted. I think Professor Beckman, you have a comment.
Yeah, I have a slightly different take on the Northeast Asia disputes, and that is these are holdovers from World War II. These are islands between Korea and Japan, Japan and China, Japan, and Russia that had been occupied by the Japanese until the end of World War II. And unfortunately, the peace treaties following did not clarify the sovereignty issue. And therefore, the sovereignty issue becomes symbols of all the evils of Japanese colonialism and so on. And therefore, it becomes, I lived in Korea for 2 years. Every Korean child is taught that Dakdo is Korean, right? Oh, yeah. And therefore, you are negotiating, you're turning over fundamental sovereignty issues to a tribunal. They're not willing to do it. In contrast, the island disputes down in Southeast Asia were not nearly as sensitive. They were kept away from the general public. The general public in both countries really didn't care very much about who won. They didn't know where the island was, perhaps. And therefore, the professionals did not let it become part of the public discourse in the newspapers and whatever. I agree with what the Koreans said. I think if the Koreans even said they were considering taking Dakdo to dispute settlement, the government would fall in the next election, because every child that's Korean is taught that Dakdo is a symbol of Korean nationalism and Japanese colonialism. You can't negotiate over national symbols. You can't turn them over to tribunals. The other one Tommy might mention is the Timor-Leste in Australia, which is another example where they invoked the dispute settlement. One, it's when you agree, but remember, if it's an UNCLOS dispute, you don't need agreement. All you need is one state to invoke the dispute settlement system, as Malaysia did against Singapore.
Yes. Maybe, Jose?
Yeah.
Jose, can I say something about the Australia Timor-Leste conciliation case?
Yes,
because people may not know about this. There was a long-running dispute between Australia and Timor-Leste over the maritime boundary in the Timor Sea. And Timor-Leste had been pleading with Australia to come to the negotiating table and negotiate a new boundary between them. And Australia had said no. And the government of Timor-Leste came to consult Professor Beckman and me on what their options are, you know? And we told them that Australia had foreclosed ICJ. They withdrew from the compulsory jurisdiction of the court before Timor-Leste became independent. They had filed a declaration under Article 298 that foreclosed Timor-Leste, taking them to arbitration, and it lost. Then Professor Beckman and I said to our good friends from Dili, there is a provision in UNCLOS which nobody has used. And this is compulsory conciliation. Compulsory conciliation, you know? And my friend from Dili said, well, if nobody's ever used it, how do you know it's going to work? And we say you have no other option, you know? This is your only option. Why don't you give it a try, you know? And lo and behold, they did. They appointed two famous international judges as their two conciliators. Australia appointed two very good conciliators, an Australian and a Canadian. And the four of them then appointed somebody from Denmark to be the chairman of the Conciliation Commission. And the Conciliation Commission worked very hard and very creatively, you know. And after about a year of hard work, actually came up with a set of compromise proposals that the two sides accepted, was embodied in a new treaty, signed at the UN in the President Antonio Guterres. And I want to talk about this because I want to tell claimant countries in the South China Sea that if you don't want to go to arbitration, if you don't want to go to a court of law, there is a win-win procedure, conciliation. And it can work because the Timor-Leste Australia case has shown you that with goodwill on both sides, it can work. You know?
That's really
fascinating. We have a book on the case.
That's fascinating. Now, of course, we did get away, and it was my fault, from the original question about Indonesia and Singapore on Article 51 of legitimate activities. I'm not sure if you want to say, either one of you want to say anything about that particular discussion. No. Okay.
Let me just make one comment, is that there doesn't have to be agreement. Either state could invoke the compulsory dispute settlement procedures. But I think my own comment is that Singapore and Indonesia have a long history of negotiating and resolving their differences, and I'd expect they'd be able to resolve this one as well. I'll leave it at that.
Okay. So there is a question on what is the prospect for the law of the sea regime, either the customary rules in it or the treaty itself, to accommodate historic rights as claimed by the People's Republic. You want to say something about historic claims made by China relating to, I assume, islands or in China?
Bob, why don't you have a go at it first?
Okay, well, I think, again, there was a long debate at the Law of the Sea Conference as to, for the economic zone, is do you give the coastal state the sovereign right to all the fishery resources within 200 miles? And to what extent do you recognize the historic fishing rights of the states that have historically fished there, because everything beyond 3 miles or 12 miles was high seas? And this was clearly debated at the conference. And the decision was that we're going to give the coastal state the sovereign right to all of the resources within 200 miles. The idea of historic rights was rejected. Therefore, states like Japan that had long distance fishing fleets that used to fish in what now became economic zones of other states had to pull back and retrain fishermen. The country in Southeast Asia that lost the most because they had the largest fishing fleet was Thailand, because Thailand is zone locked, and they suddenly found after UNCLOS came into force that most of their historic fishing rights were now the economic zone of their neighbors. And therefore, and the IC and the Arbitral Tribunal in South China Sea cases addressed this issue in detail. And it's very clear that the idea of historic rights to resources is simply incompatible with the law of the sea convention, and no state that is a party to the convention should be able to assert such rights. To me, it's quite clear.
Yeah, okay, I agree with that. And as a small footnote, I would say, Jose, that I'm responsible for the small fishing industry of Singapore disappearing, because they lost all the historic fishing grounds, so they had to close down. Singapore no longer has a fishing industry. We import all our fish.
And we have 5 vessels, I think, or 4 vessels. I'm not sure.
Yeah.
So that does remind me of one question I meant to ask you, Ambassador Coe. Is there any rule in UNCLOS that you think now, viewing backwards, you would change if you could?
That I would change?
That was a mistake, or that in retrospect was not a good idea?
I think chapter 11 as drafted in 82 was not a good idea, but you got to look at it in context, It was drafted during the Cold War. It was drafted during a period when there was a lot of interest on the part of developing countries, especially in Latin America, with looking to socialism as the inspiration for solving economic issues. And even in Asia, countries like India favored national and state enterprises over private enterprise. So the ideology of the developing country in the 60s and 70s was in favor of state capitalism over private sector capitalism. And so they were making demand that if we are going to allow the developed countries to mine the deep sea bed, we must also have an enterprise owned by the international community, representing all of us. This is a manifestation of the sort of socialist sentiment, which was strongly felt during that period. But with the end of the Cold War, with the disappearance of the Soviet Union, the interest in sort of state ideology declined. So I would say that the world changed. The world changed, and the developing countries changed along with the world. And this is why Satyanandan was able, in 1993, to negotiate all these extensive amendments to Part 11 and embodied them in the form of an implementing agreement, which the UN General Assembly adopted.
Jose, could I just add a couple points to that? I agree with everything Tommy said. I'd add simply 2 points. Is that the timing was also critical, because the Secretary General appointed Perez de Cuellar at a time when it looked like the convention could enter into force, because the terms were it enter into force 1 year after the 60th state had ratified or acceded. That meant it looked like the first 50-some states were all developing countries. No developed country had ratified it. And the whole goal of achieving a universally accepted convention wouldn't work. You'd have a convention only of developing countries. So taking the change in the political atmosphere after the dissolution of the Soviet Union, and the fact that the scientists at the time said, well, deep sea mining is not going to be for the foreseeable future economically viable, they moved quickly to say we have to resolve the problems in Part 11 in order to be able to have a universally accepted agreement. And then Satya was able to lead this with a small group of states, and it worked. So it was a combination of factors which made it work. The sad part is they addressed every one of the issues the Reagan administration had trouble with on deep sea mining, but yet, and therefore Part 11, or the 94 agreement, implementation agreement, actually meets all of the US criteria, but then the US was still not able to ratify it. and they've been not able to engage in deep sea mining for US companies. So they've lost out in effect by staying outside the convention.
So there is a question about applying or defining the provisions on artificial islands to constructed islands in the South China Sea. And the question is, why shouldn't rocks downgrade to artificial islands after being subjected to dredging and construction? I'm not sure if that question makes sense, but I'm posing it because there it is.
Let me tackle that one. One is the general principle is you can't, by artificial means, reclamation, etc., change the status of a feature. If it is below water, it's a low tide elevation. You can't turn a low, it gets no maritime zones. You can't change a low tide elevation into an island through reclaiming, adding sand and rock. And you can't change a rock into an island. You can make it big, can make it much bigger. There's no rule against expanding a feature that you have sovereignty over, but you cannot change it from one feature to another because the definition is a naturally formed area of land surrounded by and above water at high tide. So I think I'm not sure exactly what they're saying, but I think, again, if it's a low tide elevation, you can do reclamation, you can build a military base, but you can't turn it into an island. If it's a rock entitled only to a 12-mile territorial sea, you could expand it significantly, but it can't change the feature into an island entitled to a 200-mile economic zone. That is logic, and that's also the decision of the arbitral tribunal in the South China Sea case. I'm not sure that answers the question, but the question was a little bit ambiguous.
Right, I think it was. And so there's another sort of black letter question in the question box. What's your view about whether a state needs coastal states' consent for innocent passage in the territorial sea, and what was the intent of those provisions?
Well, the intent is to recognize the right of innocent passage, including warships, without seeking authorization or without even giving notice. I think that was the intent. It was the rules of the 58 Convention were clarified in one respect, is there's now a list of activities, and half of in the list are things that only warships would do. That implies warships have a right of innocent passage. There's now a list of activities which, if a passing ship engages in them, the passage would deem to be not innocent, and therefore you could escort it out or ask it to leave. Yeah. But the clear intention was to give warships the right of innocent passage. And I think the US position on challenging any state that seeks authorization or says, well, you must give us notice, that's not consistent with the convention. Yeah. If it's ever brought to a tribunal, I think the interpretation I just gave would hold.
Yeah, I agree with Bob.
Ambassador Ko, you alluded to this a little bit, but there's a specific question from Susan Finder on what exactly was the role of China in the drafting of UNCLOS. How involved was it? You mentioned that developing states owned it, but I guess the specific question is China itself.
Oh yeah, the Chinese delegation was we took part actively in the conference, and they took a low profile. They didn't take a high profile. They didn't seek a leadership position, but I was very close to the Chinese delegation, tried to explain things to them. I spoke many times to their very distinguished permanent representative to the United Nations, Huang Hua. So let me confide with you some of my conversations with the Chinese. The Chinese delegation's main role was to support the developing countries, including those that took very extreme position, you know. So I told my Chinese friend that this is not really in your long-term national interest. I told the Chinese that, you know, one day China will be a great power. You will have a blue water navy. your long-term interests are more aligned with those of the United States than with some of these extreme developing countries. So I asked them to think long-term, but I think they couldn't think, they could not imagine a day then when China will be a very successful and powerful country, will have a blue water navy, and which has happened now, So my argument to my Chinese friends then, 30 years ago, has come true, So I would say today, on maritime navigational issues and so on, the Chinese and the Americans actually have the same interest. They shouldn't be on opposite sides. And the Chinese shouldn't be taking positions like innocent passage of warships through the territorial sea, which is really not in their own interest, because they will have a navy that will be going all over the world. It will transit the territorial sea of other countries. Are they going to ask permission or give prior notification? The answer is no, So 30 years ago, I had already anticipated a day when China would be a powerful country with a blue water navy, and I told them to stop supporting all these extreme claims of the developing country because they are not in your long-term interest. But they didn't listen to me.
Jose, can I make one comment?
Sure, please.
For those that want to understand this issue, I would urge you to look at a map of Asia and a map of China. And you'll see that China historically saw threats from land. It saw the Mongol hordes coming over, etc. They were a maritime nation for a while, but for a long time they were sort of a land-based nation. But if you look at a map and you see now, if China wants to go to the Arctic for the Northern Passage across the Russia, or if it wants to go to the Pacific Ocean, or if it wants to go to the Indian Ocean, it must pass through choke points under the sovereignty of other states. And therefore, now that it is becoming a naval power and superpower, it has exactly, I agree with Tommy, the same interests of other superpowers has. It is going to want to exercise the passage rights of innocent passage without seeking authorization or consent. It's going to want to pass through the Indonesian archipelagic waters, through the Straits of Malacca and Singapore, through the choke points off Japan, and so on and so forth. And therefore, it should start, I think, reevaluating its position. And I would say that I always joke that they should send a thank you note to the Soviet Union and America for negotiating provisions which protect the interests of naval powers, because they're going to be the next naval power. Not to challenge don't challenge rules which benefit you. It doesn't make sense to me.
So, Ambassador Coe, you are known as a great negotiator. And so Jerry Cohen is taking that title very seriously. He's asking, please suggest a basis for a compromise between China and other powers regarding the South China Sea. How would you solve this mess?
Well, first, I want to pay homage to Jerry. Jerry is not only an old friend, but I consider him one of my gurus. And so salutation to Jerry. On the South China Sea, I have actually in private spoken to my Chinese and Vietnamese friends and say that, for ideological reason, one of you, namely China, is not prepared to take your dispute to a third party. Why don't you derive inspiration from the Australia-Timor-Leste case? Why don't you seek a win-win solution through conciliation? I think conciliation is a procedure which the Chinese should consider seriously. I know that the Chinese national policy is that on disputes involving sovereignty, they will not take it to a binding third party. Okay, I think they should reconsider that, because if they want to be a great power, I think they should change that policy. But in the meantime, why not try to find win-win solution to some of this dispute through conciliation? With goodwill on both sides, it can work. And And the other thing I want to say to my good friends in China is that the way you deal with the ASEAN countries is so important to your reputation in the world. China claims that its rise in the world is a peaceful one. It's of no threat to its neighbors or to any other country. The best way for China to demonstrate that this is true is to treat your neighbors in Southeast Asia on equal terms, to respect international law, and not to resort to coercion, to force your views, even if they're not in line with international law. This is my sincere plea to my Chinese friends.
Professor Beckman, do you want to comment on that at all?
I'll just make a quick comment. First, I would like to say hello to Jerry and my apologies for not sending him a note when he retired. I didn't learn about it until quite a bit later. He is my mentor, the person that got me interested in East Asia when I was at Harvard. In terms of the South China Sea, I would agree with Tommy except for one thing. I would suggest conciliation, but leave the sovereignty issues off the table and say, to what extent can we leave the sovereignty issues aside and cooperate? And one of the issues could be, for example, the Regional Fishery Management Organization that we now have China as the largest fishing entity in the world, but the Southeast Asian countries are also major fishing entities. And the current situation where Chinese vessels are coming into what Indonesia and Philippines and Malaysia believe is their economic zone is a disaster waiting to happen. But they should be able to work out a fishery management organization, setting aside maybe where the economic zone boundaries are. How do you manage the fisheries sustainably in the South China Sea? And maybe a conciliation commission comprised of legal and fisheries experts could help them do that. If they don't do it, we're going to have, by weight, more plastic in the South China Sea than we are fish. Hydrocarbons is a much more difficult issue, but again, there may be ways in which conciliation can work out arrangements where the Southeast Asian countries are willing to engage CNOCC or other Chinese companies to help them exploit the resources. That would be very difficult in Vietnam, but with conciliation, it could be possible.
Yeah.
So there are a number of other questions, so I'll try to ask these more quickly and see if we can get responses. One is climate change. Will climate change the interpretation of anything in the convention, including rock, baselines, for example, due to sea level rise? How do we think about that?
I quickly say we're looking at this very carefully. Our new director at CIL is now a member of the International Law Commission that's examining this issue. We've had several workshops. We're engaged in it. This one thing is an issue is the assumption is that you draw your maritime zones from your low water line along your coast. Well, and that assumes it's ambulatory. If your water line changes, redraw your zones. That whole issue is being rethought of because of climate change. Because islands are disappearing, coastlines are retreating, and what is the legal consequence of that? The ILA is also studying the issue. That's the main one. And islands could disappear and entire island states could disappear. Yeah. So you raise the theoretical question, can a state exist and manage fisheries when it has no land anymore?
So there is another question concerning the normalization and frequency of maritime gray zone type activities, especially in the economic zones in South China Sea by certain states to pursue expansionary maritime claims, advocate for their own revisionist interpretation of the law of the sea. Do you think UNCLOS and the wider body of the law of the sea are resilient enough to respond to the use of these activities? How do you think international law should develop such that these activities may be better governed or even prohibited, particularly in the maritime domain?
Tommy, you want that one, or I should take it?
No, you take
Let me
it.
just make a quick comment. I think that the so-called gray zone area, that is an issue that is very ripe for the conciliation process in terms of what do we do with the so-called maritime militia? What do we do with, you have Coast Guard vessels that are simply painted white and they're larger than naval vessels of other countries and so on. The new Coast Guard law, these are all issues which potentially raise possible conflict if things get out of hand, and therefore to deal with a maritime security issue, I think both sides have to sit down. If it's not working through the code of conduct negotiations, there maybe is a conciliation can help them establish a set of rules which would minimize the risk of conflict. That's a higher priority even than fisheries.
So now we get to, I think, the final question, and it goes to Ambassador Coe. So what makes for a good negotiator? What was the most important skill that you developed that led to your success in so many realms of international law? That's a great final question.
I would say good luck.
Oh, actually, I think that's more a modesty than anything else.
Okay, I'll be more serious. I think if you're going to be a sort of neutral chairman, facilitator, one of the most important things you must do is to earn the trust of your colleagues. Your colleagues must trust you. And you must, of course, work hard to understand, what the issues are, what the competing interests are, what are the minimum national interests of the various parties involved. And you must then be creative and think of compromises that accommodate these competing interests that it's not ideal, but everybody can live with, So it's hard work, it's listening to the parties and understanding them, is coming up with creative win-win solutions, and nothing would be possible if they don't trust you.
Thank you. And I trust that answer. And unfortunately, we come to the end of our 9 o'clock hour here, at least on the East Coast. Thank you both for a stimulating conversation about the law of the sea, and hope to have you back, Ambassador, for any of your 3 books coming up, and Mr. Beckman on all the things that you're studying, including the cutting edge issues, and I hope both of you can come back. We have a thank you to all of you from Peter Dutton and others. Thanks again.
Thank you.
Take care.
Thank you.
Bye-bye.